and equitably. All madhab require this. The text also makes it clear that if one cannot do so, then marriage to only one wife is permitted. The issue of termination of Muslim marriage is dealt with in Section 9 of the MMB. Some problematic issues are raised here. The bill rules maintenance for all forms of iddah at marriage dissolution. This is a disputed issue, as according to some fuqaha, there is no maintenance due when there is no corresponding right of reconciliation, and this is the view of the majority of the fuqaha of Ahlul Sunnah. Thus, no maintenance is required according to this group of fuqaha in the case of irrevocable dissolutions where the wife is not pregnant. The bill has taken the view of some fuqaha who rule maintenance for virtually all forms of Muslim marriage dissolution. A magnanimous divorcing spouse will not take offense at such a ruling if he is imbued with the spirit expressed in the Quran on marriage dissolutions. Failing to register talaq with the relevant authority is criminalized with a heavy fine of 20,000 rand. The issue of registering a talaq does not feature in any Sharia text as such. The question arises whether this is prohibited Sharan, especially in our contemporary world. Many Muslim countries only allow Muslim marriage to take place in the Sharia court, and logically require that the talaq process take place there too. This ensures proper records are found and avoids disputes of a fundamental nature where only the spouses are present and having one word against the other with no witnesses. There is thus great maslahah herein, which the lawmakers of those Muslim countries must have taken into consideration when writing their respective family and personal laws. If a talaq is not registered here, we will have the same status and problems we have presently. No one knows who is divorced here, save if there is documentation. A prospective groom or bride, for that matter, can lie as to his or her marital status with devastating consequences when the truth surfaces later on. If a person is registered on his own free request as a marriage officer, he knows at inception of assuming such a position that he will be required to register the divorce of those married under the MMB. It is the administrative carelessness that is being penalized due to the serious consequences it will have on the lives of people. Perhaps one can argue with the scope of the fine levied in this case. A far-ranging new process is envisaged for dissolution and post-dissolution of marriages where current South African legislation will become applicable. As is universally known, all over South Africa there is no system of a Muslim post-divorce care and supervision of parties' responsibility in the aftermath of a divorce. All know the problems arising from such an untenable situation. The family advocate of the High Court will play an important role in settlement matters as far as it affects children. How far Islamic practices of custodial guardianship will feature in such a scenario is unknown. We know that the fuqaha themselves have differed very widely herein, and much of their rulings are based on ijtihad. Needless to say, a purely sectarian view on custodial guardianship will cause serious problems for those who insist on this kind of solution in this matter. Section 9.2 makes provision for a Muslim marriage to be dissolved by a court on any permitted grounds as in the Islamic law. This is in addition to Section 2 of the Divorce Act of 1979, which makes an irretrievable breakdown in the marriage grounds for a divorce. In this regard, the scope for divorce is wider in the MMB than in the Divorce Act. The relevant section in this Section 9.2 mentions, as elsewhere, Islamic law and does not specify any madhab. This is a pertinent feature in the MMB and could be the cause why certain criticism of it had been vehement. Post-divorce settlement has also been placed on the MMB. Post-divorce settlement is not new to Sharia or to fiqh. It is well known that the Sahaba gave their spouses on divorce gifts of clothing and money. Contractual obligations set in a Muslim marriage contract becomes binding on divorce and must be executed as promised. Wives are not taxed to contribute to maintenance of the marriage home. All expenses are to be borne by the husband. In Sharia, her duty is that of a wife and a mother only. Any enrichment she causes a husband to procure in his work or business and related matters are outside the scope of Muslim marriage. These extraneous activities must thus be rewarded at market value. Clause in the MMB to this effect is thus not repugnant to the Sharia. In matter of housekeeping and carrying out household chores, some fuqaha require the servants to be hired to do this work and be paid by the husband. They see this as part of the requirement of maintenance of the wife. Even the hadana of the infant, it's a custodial guardianship, especially the breastfeeding of such a child, is against a fee under various circumstances according to the different views of the fuqaha herein. Interestingly, some fuqaha also insist that the wife must not do any work which will harm or injure her or which diminishes her beauty. Can you believe it? As far as custody and access to minor children are concerned, Section 10 of the MMB states that the Islamic laws of custodial guardianship and the recommendation of the family advocate of the High Court will decide such issues. The section does mention on more than one occasion that there must be regard for the Islamic law herein. In the issue of maintenance, there is no fundamental or serious difference between the Sharia requirements herein and the MMB. The compulsory mediation clause in Section 12 of the MMB resembles some processes in the arbitration of the Hakam system in Islam. The Hakaman or arbitrators, according to some fuqaha, have more powers than the proposed mediation council in that they can actually effect dissolution of a marriage. In conformity with secular laws internationally, only judges of courts effect dissolution of marriages. This is not unknown in Sharia, as Qudat, judges, Muslim judges, only issue fas and annulment or tatliq, or judicial divorce. If arbitration fails after 45 days from the date of referral to the mediation council, the court will adjudicate the matter. This process is similar to the Sharia one in that if the Hakaman cannot effect a reconciliation between the parties, the solution of the marriage bond will be effected by the court or the Qadi. The most striking difference between the copy of the MMB issued by the Ministry of Justice this year and that of the South African Law Reform Commission handed to the then Minister of Justice in 2003 is that Section 15 on courts and assessors of the South African Law Reform Commission's version, South African Law Reform Commission version. In it, the judge president is required to appoint a Muslim judge to hear the dispute and be assisted by 2 Muslim assessors with specialized knowledge of Islamic law. In the latest ministerial version, this is completely omitted. This gives rise to concern, and most of the serious criticism is leveled against this. It is not only the letter of the law that is important, but also the spirit of the law. Here, a problem will occur for a learned judge in the letter of the law of a community will not necessarily have the feel of the spirit of that law, nor is he or she conscientiously bound in a religious sense in his or her deliberations and judgment in the matter. Further, the Mufassirun and the Fuqaha rule that due to the ayat in Surah Nisa, 141 I think it is, non-Muslims have no authority over Muslim matters of their laws. One may ask if this omission is not prescribing to religion on how it is to conduct its own religious matters and how it interprets and practices its own faith. In conclusion, thus, there are a few issues in the latest version of MMB which are problematic. For the entire process of a relatively successful application of Muslim marriage law to function relatively smoothly, there must be no constitutional obstacle to the functioning of the said law. The issue of who settles disputes and how the judicial process will develop the Muslim common law in the application of the proposed bill is also a vexing problem. The issue of Sharia courts is completely absent from the bill due to its thrust being accommodation within current legislation and legislated structures. In terms of reference to the South African Law Reform Commission, was also restricted to find ways and means of accommodating Islamic marriage laws within the South African law. Another very glaring omission is that one of the main consequences of a Muslim marriage succession had been completely left out. This shows that there had not been a proper understanding of the functioning and consequences of the Islamic family and personal law. The author repeated refrain that of inequality and injustice in Islamic inheritance distribution would have been refuted. One may also notice that there has not been the magnanimity shown to non-Muslim religious minorities as it is shown in practice in the Islamic system of government. All such denominations and sects see to their own family and personal law matters, including their religious endowments, schools, and related institutions which the Muslim state recognizes. This includes the ecclesiastical court staffed by such minorities as officials. For this lenient system, the peace is kept in one of the most sensitive institutions of society, the personal and religious lifestyle of people. These systems function all over the Middle East, especially, and even Israel has retained the Ottoman administration hereof for its religious communities, Muslim, Christian, Druze, and Judaic. One would have hoped that Qudesa would have come up with new institutions for a new millennium in dealing with minority matters, some system that would have been markedly different from the productions of the old European democracies and which fitted into Africa. This, unfortunately, did not materialize. Shukran. Thank you.
Jazakallah, and that is actually one of our presenters who stuck to his time limit. I think you need 7 kusistas for that, Sheikh. We'll now have a response from Mufti Ibrahim Smith, who is with the Faculty of Issuance of Islamic Verdict from Dar al-Ifta in the Western Cape, and thereafter we'll take some questions on the specific presentation.
Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Alhamdulillah wa kafa wa salatu wa salamu ala ibadi alladhina istafa wa ala ali wa sahbihi wa man wala wa ba'd. Al-Wasatiyya, or seeking the middle way in Islamic affairs, is indeed a commendable act. Almighty Allah has commanded us to seek the middle way in metaphysics, aqidah and belief. In the following verse, say, O people of the book, exceed not in your religion the bounds trespassing beyond the truth, nor follow the vain desires of people who went wrong in times gone by, who misled many and strayed from the even way. Ma'idah 77. In another verse, Allah says, guide us on the straight path, the path of those whom you have bestowed your favor upon, and not the path of those whom has earned your anger, and nor those whom are astray. This verse is indicative that the straight path is indeed the middle path. Surah Fatiha verse 6 and 7. The middle path in Sharia is found in the following narration: I fast and I eat, and I sleep and I pray, and I marry a woman, and whomsoever turns away from my sunnah is not from amongst mine, agreed upon. Muslims are compelled to show the greatest respect to the Sharia and to protect its sanctity at all times and places. The Sharia is valid and applicable to all past, present, and future eras. This fact constrains Muslims to adopt an uncompromising stance regarding Sharia provisions. The Holy Quran itself is emphatic on its requirement from Muslims to govern and be governed by the law of Almighty Allah, which was revealed directly by Him and expounded by His messengers with practical demonstration. Almighty Allah severely warns those that judge by any other law in the following verses. And those who do not judge by that which Allah was revealed by Allah, they are indeed disbelievers. In another verse, and those who do not judge by that which was revealed by Allah, they are indeed transgression or oppressors. In another verse, Almighty Allah subhanahu wa ta'ala says, and those who do not judge by that which was revealed by Allah, they are indeed fasiqun, those who transgress. In the following verse, Almighty Allah subhanahu wa ta'ala says, then do you believe only in part of the book, meaning the Quran, and reject part of it? Then what is the reward for those amongst you who do not so other than disgrace in the life of the world, and on the day of judgment they shall be consigned to a more severe chastisement. 285. Verses of this nature constrain Muslims from comprising the requirements and imperatives of Islamic law as a general rule. Being the law of Almighty Allah, Muslims are not allowed to depart from the Sharia position or to resort to loose and baseless interpretations of the law that in any way violate or infringe the law in letter or spirit. Unqualified arbitrary interpretation is considered an infringement of Islamic law and is bound to ultimately result in the mutilation and disfiguration of Islamic law. The apparent reservation that some Muslims hold for certain dubious provisions contained within the draft bill need to be understood in the context of the above-mentioned viewpoint and verses. The sharp reaction from ulama to these provisions must be understood in this context. The ulama, by virtue of being Sharia scholars, are considered the custodians and protectors of the Sharia. The ulama are thus constrained to respond to rectify any violation of Sharia imperatives as an essential obligation and duty. It has been the historical legacy of the ulama to oppose any attempts at subverting the Sharia or any of its provisions, either in letter or spirit, throughout the history of Islam, despite the formidable odds that faced them in this endeavor. Hiding behind a facade of legislation in some semi-secular Muslim states, the draft bill borders on subverting the spirit and letter of the Sharia. In certain provisions, there is a noticeable tendency for supporters of the draft bill to argue based on existing legislation on family or personal law in certain Muslim countries as a legal and legitimate basis for certain provisions in the bill as being Sharia compliant, and when this may not be the case. This line of reasoning is untenable and erroneous, for the Sharia position is derived independently from its original sources of law, the Holy Quran and the authentic Sunnah of Muhammad sallallahu alaihi wasallam, as well as the verdicts of recognized and undisputed jurists like the four madhahib. If the legislation of deviated rulers and governments could serve as a legitimate and recognizable source of Sharia law, the Sharia law would have been virtually unrecognizable today from its original identity and self. It is for this reason that leading Islamic jurists across the centuries of Islamic history have zealously guarded their independence from rulers and governments and fiercely retained this freedom so as to be able to advocate the true Sharia position without reservation or trepidation. The influence and footprints of Western culture is unmistakably present in many of these modern reforms of Islamic law of these countries. Muslims in South Africa has lived in cordial with the government. The proposed bill is the product of various Muslim bodies lobbying for recognition rather than the government imposing it on South African Muslims. I shall focus on a few clauses within the proposed bill. Number 1, a non-Muslim judge presiding over Muslim affairs. The draft bill suggests a system of 2 Muslim assessors with specialized knowledge of Islamic law, sitting alongside the judge, with the ruling of the court being based on the view of the majority. This raises several issues from an Islamic perspective. Number 1, is it allowed in the first instance for a non-Muslim judge to preside over Muslim matrimonial disputes?
2 minutes.
According to a unanimous view of eminent Muslim jurists, this is essentially outlawed. More than likely, this will result in the subjugation of Islamic law to the dominant legal and judicial system, which is foreign and divergent to the Sharia. It could also lead to a situation where aspects of Islamic law will be interpreted, meaning ijtihad, by non-Muslims or ill-equipped Muslim judges, which is unacceptable. The pronouncements of the court are always and have always been in accordance with South African law, never according to what it perceives to be Islamic law. In fact, in a recent judgment, the judge emphasized that in issuing his decree, he is not taking cognizance of the Sharia. In the Constitutional Court, Judge Kabedi, in the Hessam case, commented, "In the view I hold of the matter, it is not necessary to become entangled in the religious and cultural debates in this matter. It should also be emphasized that this judgment does not purport to incorporate any aspect of Sharia law into South African law." Polygamy, number 2. Polygamy is a legitimate institution both according to Quranic text and prophetic traditions and practice. Although the draft bill has not outlawed the practice of polygamy, summarily such restrictive measures have been placed around a valid Islamic practice that makes its practical application virtually impossible or extremely difficult. This is tantamount to interference in Islamic law and an imposition of that which has not been imposed by Almighty Allah Himself in the Holy Quran. It is ironic and highly lamentable that society, law tolerate the existence of adultery as a right, a privilege, and a freedom to be enjoyed by citizens, but polygamy is outlawed and proscribed. The administrative regulations and penalties of MMB are designed to prevent polygamy, to make it impossible for a man to take a second wife. the approval of the court, the approval of the first wife who must join the husband in the court application for approval, the division of assets, the encumbrance of property regime. Why are these same criteria not applied when a man marries the first time?
Time's up.
Shukran.
Okay, now we really are into it. So let's, and say Jazakallah so much to Sheikh Mufti Ibrahim Smith. Right, the mic will go around and we'll take some questions for the next 10 or 15 minutes. Can I ask that we compound those questions and let's not really go into lengthy explanations to try and take as many questions as possible. Also indicate to me who you're directing your question at. Can we see some hands so that Halil knows where to direct the microphone to? Sheikh Tawfa, if you could also join us in front, please. I thought the MMB for sure would get them going. Do we have a question on the floor? There we go.
Okay, assalamu alaikum wa rahmatullahi wa barakatuh. I guess the question is both to the first sheikh who spoke about the Muslim Marriages Bill as well as the respondent, Mufti Smith. My question was, firstly, if you could just reiterate the ayah that you referenced in terms of non-Muslims presiding over Muslim matters. Surah Nisa 141. Okay. And then the second issue was more, how do you reconcile the fact of non-Muslim judges judging over Muslim matters not being allowed when we are a minority population within a South African context? So all the time, non-Muslim judges are residing over Muslim cases, not necessarily family, I'm sure family law as well. How do you reconcile us as a minority where we are living under non-Muslim, if we want to delineate it like that, non-Muslim judges? Secondly, you say that we don't believe that there'll be an equitable approach from a non-Muslim in resolving Muslim personal law issues. But I think that that does a disservice to how important religion is in formulating laws, and I think that when you cited the case of the man who said he doesn't take religious and cultural precedents into account, the subjectivity of religious and cultural precedents is a problem when enforcing justice, in my view.
All right, can we have the respondents answer now, please, so that we can also take a few more questions? Sheikh Tawfa?
So let's start. Bismillah ar-Rahman ar-Rahim. The issue of non-Muslim judges adjudicating in South Africa, we've got no control over that because this country's got a constitution and they are the majority, they make the law. So whether we like it or not, they are there. It's the first point. The second issue, the issue with this MMB here is that, as the Mufti also said here, there's not an enforcement of the law to say you must take the MMB as your criterion for regulating your marriage affairs. You have a choice. So the issue of having a non-Muslim judge in certain matters, which South African law operates like contracts and things like that, you have no option. What can you do? They'll force you to the court. If you don't do it, they'll lock you up for contempt of court. So this is the situation we must recognize and realize. When you are a minority, there's a difference between a Muslim minority and a Muslim majority. It's two different things. When a Muslim majority, there's the Qadi, no problem. But when our system, our Muslim government is much more superior than Western systems. We don't interfere in other people's religions. They can have their own judges do their own things, so we don't have to squabble about it. So this kind of question would not arise in that situation. When you reverse the scale, then it doesn't apply. You don't have any independence when it comes to that kind of situation. So by that regard, we are far superior than all democracies in the present day world also. The other issue about the judge being not being impartial, I think if I get it right. Every human being has prejudices, and no matter what it is, we grow up with it. So there's no way you can say any judge anywhere in the world, whether he's Muslim or non-Muslim, anywhere, that he is absolutely 100% objective in what he or she is doing. You can't guarantee that. It always flows in. You see the European court, how they do it, how the European courts do the issues with these people who are being tried in front of them with various kind of Islamic phobic kind of trials. They have a pointed picture in their mind and the way how they do. They just clothe it in legal terms and in legal permissibilities and issue the judgment. This is a style. So you can't say that that you can't say every non-Muslim judge is going to do that. No. But in most cases, I feel personally, I said personally, that you cannot be absolutely independent in that regard. And if you don't know the spirit of the law, there's a big problem. Islam has recognized that. That's why we cannot sit in judgment on other communities, because we don't feel the spirit of that law. It's not just the letter, the spirit. And it's that spirit which is so important, with a letter, to go together to give you a better and balanced view. I hope I've answered.
I think the question was also directed at the respondent. Mufti, can we try and get that quickly? We're running out of time, so if there's anybody else that's got a question, please indicate so that we can come to you immediately. Mufti, please.
First and foremost, it's impossible or virtually impossible to reconcile. Number one, those people who goes to court are going out of their own accord because of monetary or financial gain. They still refer to the ulama to find out if the nikah is valid, and if it's still permissible to live with a particular person. But for monetary gains, they run to the court in order to get post-iddah nafaqa or any other sort of propriety rights. Then they go to the court. But that which is coupled to permissibility, then they refer to those people whom they term and call ulama in a advisory capacity. You know, people blame the ulama and say you only act in an advisory capacity. You're only there to advise. You cannot enforce the law. That's why we run to the courts. But no one actually went to the court to have their divorce nullified or the nikah nullified, for that matter. They only go because of financial gain in order to retrieve their mirath or inheritance.
Right, point taken. There was another sister here who had a question. Was there somebody else? All right.
Assalamu alaikum. My name is Faiz Khirdin. For the sake of clarity and complexity, I would just like some, I don't think you can have a short answer, but the question is, what's the difference between the Sharia and the fiqh? I pose it to the panel.
Can I perhaps pose that one to Sheikh Siraj and have Sheikh Siraj answer that one?
Me?
Yes.
It's the only one Siraj here.
Okay, there are lots of discourses on these things. For example, you know, there's a particular school of thought to believe that Sharia is something ineffable. It is something that only lies exclusively in the mind, as it were, divine mind. There's another more practical one when we're speaking at the level of mu'amalat. Sharia, for example, is a much more comprehensive term than what fiqh is as such. And we need to understand this very carefully. When we speak in normal terms, if Sheikh Tauf and I would be speaking about Sharia and fiqh, I would know we are using it in a non-technical sense, that we'd be understanding each other. But technically, Sharia encompasses much more than fiqh, for example. Sharia encompasses things such as aqidah, or akhlaq, or morals, a whole host of things, even the siyar of Rasulullah sallallahu alaihi wasallam, and akhlaq and adab and all these things. It's much broader in its context. The fiqh is subsumed under the Sharia. And that's sometimes where the problem happens, where the problem occurs, where we divorce and draw the line to find between the fiqh and the Sharia. The fiqh, but broadly analyzed, consists of the legal tenets and the way and manner in which we perform and do jurisprudence, for example. Slightly different from usul fiqh, but it's informed by usul fiqh. The fiqh, furthermore, is divided into what we call the mu'amalat, aspects of mu'amalat, and then the aspects of ibadat. Mu'amalat dealing with hajj or salah and these things. The mu'amalat is what we are dealing with here. So the Muslim personal law, for example, falls under that subcategory of mu'amalat. And as Sheikh Tauf and Sheikh Smith here would know, that these are the most contentious points of dispute because of the degree of ijtihad that has gone, which Sheikh Tauf continuously, and that is why he so continuously emphasizes the fact, almost every second, third point, this is a matter of ijtihad. This is the caution that one needs to exercise, I think. The mu'amalat, whether it is inheritance, whether it's commerce, whether it's Muslim personal law. Muslim personal law, of course, on the whole, is a highly contentious issue throughout the world. Our concerns are, of course, and Sheikh Tauf and I have been for years involved in Muslim personal law. I must admit that we have to be frank. I prefer frankness about these things. Both Sheikh Tawf and I walked out in one meeting. He walked out first and I walked out second. And I was followed by a third person. And this particularly, you remember that, Sheikh Tawf? You read out in Durban it was. You sat behind me and I walked out for the same reason. The fact of the matter is, I didn't get to what I wanted to say. You can shout me down and stop me if I'm going too far. Yeah. This is what I think is so valuable about Rashid Umar's paper, where I'm trying to give a broad sort of introduction to what it means to act as a minority and how we behave, what the parameters, what are the constraints as minorities, and what are our rights. Do we take a supremacist attitude? Do we take a more humble attitude? Because we are commanded virtually by consensus, I'm not quoting Ijma on this, but virtually by consensus to obey the law of the land as Ahlul Ahad. And that is a very, 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 very critical point. However, what I see in the broader, as the keynote address is normally, of course, a bit much more general than what the others are. They are moderated, I'm not moderated. You can question me, okay. Nonetheless, the fact is, there are two aspects of engagement that we need to address. And that is, I think, Rashid Umar very pertinently mentions that in his one work here. I've got it written down there somewhere. Muslim minorities in post-South African apartheid. That where we are having huge problems, and we cannot turn our backs on this. We cannot ignore this. While pluralism and engagement and activating the central concept of the middle way in Islam as an Ummatan Wasata has a double-edged, double-forked sort of challenge. One, extrinsic with our fellow believers, Christians, Jews, Muslims, etc., etc. The other is dealing with our own internal, those polyphonic voices within our own communities. And that is what we see happening here, even right now, is that there's a polyphony of voices, one saying one and another saying the other. Is it not so? But this is, it makes for productive discourse and discussions.
All right, Sheikh, I'm afraid I need to leave it there because we've run out of time. Okay. I need to move on to the second presentation, but I think the second presentation will pick up exactly where that one is left off. So our thanks, Jazakallah, to our previous panel. And let me now at this point call up, we're now going to look at an indispensable living tradition, the middle way approach to the Islamic scholarly legacy. It was supposed to be delivered by Maulana Taha Karan. Unfortunately, he's not feeling well today, but he has commissioned or instructed Maulana Riaz Saluji, who hails from Canada, to do his presentation. And the respondent on that will be Dr. Andrea Brigalia, who lectures in Islam at the University of Cape Town, and we will also take questions on that. So can I ask Maulana Saluji to take the mic for us, please?
Bismillah. الذي لا إله سواه الواحد الأحد الفرد الصمد الذي لم يلد ولم يولد ولم يكن له كفوا أحد والصلاة والسلام على أشرف الأنبياء والمرسلين وعلى آله الطيبين الطاهرين وصحابته الصالحين الغر الميامين ومن تبعهم بإحسان إلى يوم الدين اللهم اكتبنا منهم آمين. السلام عليكم ورحمة الله تعالى وبركاته. So I'd first like to begin by, there's a statement in English, many of you probably are aware of it, famous last words, don't shoot the messenger. I'm deeply sorry that Maulana Taha could not be here, and I would not stand before you had he not commanded me to come and deliver this on his behalf. We're looking at the subject of the indispensable scholarly legacy. I'd like to first begin by reminding myself and you that Rasulullah sallallahu alayhi wa alihi wa sahbihi wa sallam teaches us that the ulama are the inheritors of the prophets. What then is the salient feature of the legacy that the ulama leave us? That continuous chain of the acceptance and transmission of ilm until our present time. What I would like to do is not speak in the abstract. I don't want to give you a pedantic lecture about our tradition. What I would prefer to do actually, and this would be a means of connecting us to Maulana Taha as well, to speak about probably Maulana Taha's most beloved alim and scholar, one that resonates certainly in Cape Town, as most of you, most of us would be of the Shafi'i school. I'd like to speak about the life of Imam an-Nawawi rahimahullah and the way in which his life elucidates and elaborates and so beautifully illustrates some of the most important and salient themes of our scholarly legacy. I'd also like to suggest that his life indicates to us what is the middle way. We do not define the middle way and impose it and project it on the Shara', but rather the scholars and the ulama, they would explore and reveal in their human capacity what Allah wants and what Allah loves. Let's look at Imam an-Nawawi for about 20 or 25 minutes. 3 themes, I think, pervade his life. One of my teachers, Maulana Shamil, is not here today, but he once told me that one of the very old and very revered ulama of the Tablighi Jamaat once spoke to them and advised scholars and the practitioners that the character of Rasulullah sallallahu alaihi wasallam can really be summarized in 3 very simple ways. And once I heard this statement, it became indelibly etched in my mind, because it's a beautiful and profound and so true about his character sallallahu alaihi wasallam. So he said that if you want to walk in the footsteps and the heart steps of Rasulullah sallallahu alaihi wasallam, then bear in mind that he had 1, a cool mind, a cool, calm and collected mind. 2, he had a wide, embracing heart. And 3, he had a soft and sweet tongue. That resonated in my mind as I was looking at the life of Imam an-Nawawi, and the 3 points and themes are very similar, because he was indeed a very fitting and proper heir to the legacy of Rasulullah sallallahu alaihi wasallam. So the first point would be a pure heart connected to Allah subhanahu wa ta'ala. Secondly, a clear mind, rooted in the depth and breadth of the Islamic legacy. And thirdly, a body dedicated to welfare and service in confronting the needs of his time. Imam an-Nawawi was an example of the consummate, engaged scholar. A quick biography. He was born in Nawa, which is south of Damascus. He was born in 631. He comes from a family that were not comprised of notables and were not known for scholarship, although his father was a very, very pious man. His father actually had a food and vegetable garden, and he would feed his family from that, because he was assured and certain that everything was halal and made by his own hands. A number of people in Damascus, in particular some of the scholars, noticed in Imam an-Nawawi a precocious desire for learning, something that set him apart from his young peers. There's a story about him that he used to spend much of his time, even as a very young boy, reading and memorizing Quran. And there's an interesting story where the boys of that town of Noah wanted him to play with them, and they insisted and they chided him for doing that. And they finally got him to break away from his studies for a few brief moments, and he cried. And he cried. And he bemoaned that because it was time spent away from studying. His father, noticing that, sent him to Damascus when he was 18 years of age. He studied at the Rawahiyya school for a period of 6 years. And the stories of his scholarship and his studiousness and his seriousness were legendary. It was reported that, he himself reports that for the 2 years that he was there, I think in private study, he never slept on his side. He would sleep sitting in a sitting posture, reading his books. And when sleep would overcome him, he would fall off to sleep, and the moment he would wake, he would go back to his studies. It is narrated about him that his room was so small, and it was filled with so many books, books upon books, amassed books, that when guests used to visit him, he would have to move the books around in order to find space for his guests. He started teaching at the Ashrafiyah when he was 24 years old, and towards the latter part of his life, a decade or so before he died, he began to author books. He died having finished more than 50 titles. He never married. He was one of those ulama, like Ibn Taymiyyah rahimahullah, who never married. And he died in his father's house in Noah at the age of 44. Let's look at his times. Three broad categories that would correspond to the themes in his life. In terms of the spiritual state of his time, Imam Nawawi lived in a time when the Mongols had sacked Baghdad. And there was a general, if you would like, spiritual malaise that preceded that. In terms of ilm and scholarship, the Shafi'i madhab was still in a period of development. The two schools at that time, the famous schools of the Shafi'i and the repositories of ilm, were Iraq and Khurasan. And in each of those epicenters of learning, the madhab had been compiled, but yet not systematized, and yet not authenticated. And in terms of the social and political climate, we mentioned that the Mongols had sacked Baghdad, and there was the emergence of the Mamluk dynasty. And Imam An-Nawawi rahimahullah, he lived in the first part of that period of governance of the Mamluks, and it was a period characterized by internal divisiveness and external threat. The Crusaders encroached on Muslim lands from the west, and the Mongols from the east. Now turning to those themes. The first one, and I purposely prioritize them in this way, inshallah, that you would agree with me in terms of their succession. A pure heart connected to Allah. You find in Imam An-Nawawi's life a very profound command of the Islamic spiritual legacy. From what we know, he was not of any particular tariqah. Many of the Shafi'iyya were, but Imam An-Nawawi he didn't ascribe himself to any formal spiritual school. Although he wrote on the subject, and his life is a sterling example of the values of tasawwuf, or tazkiyah as you prefer, embodied and manifested. He writes with great clarity and great vigor and great power when he writes about tasawwuf. And it was interesting, last night I was reading one of his definitions of tasawwuf, not being, if you like, a formal practitioner of that, but his definitions of tasawwuf are prescient and very, very powerful. I'm just going to list two or three of them because you will see and you would agree with me, inshallah, that he lived that down to the very last detail. He says, among the basic rules of tasawwuf, indifference to whether one accepts you or whether one rejects you. Satisfaction with Allah Azza wa Jal, whether in plenty or whether in scarcity. In terms of the foundations of these, one of the points that he mentions is giving the best of service. And in terms of principles of tasawwuf, among the many that he mentions is this one: foregoing dispensations from religious obligations and foregoing figurative interpretations for the sake of cautiousness. Secondly, in terms of this idea of the ulama having their hearts connected to Allah subhanahu wa ta'ala, an unimpeachable and exemplary character. In this way, many of the ulama have described him as the most authentic heir to the legacy of Rasulullah sallallahu alaihi wasallam. That legacy being a legacy of ilm, because the ulama, because the anbiya lam yuwarrithu dinaran wala dirhaman, bal warrathul ilm. They do not give off in their inheritance of money or power or prestige, but they give ilm. وَمَنْ أَخَذَهُ أَخَذَ بِحَظٍ عَظِيمٍ, says he sallallahu alaihi wasallam, and whoever grasps that or internalizes that and lives that has truly achieved something tremendous. We find that he has exemplified in his life the most beautiful prophetic and Muhammadan characteristics of mercy, of rahmah, of forgiveness, of hilm, of justice, of adl and insaf, of patience, of sabr, of charity and generosity and magnanimity, and of remembrance of Allah subhanahu wa ta'ala. As a matter of fact, he was known never ever to allow his servants, his students, and yes, as students of ilm, we are servants of our teachers. He would never allow his students to serve him out of his sense of haya and his sense of modest sensitivity. But he would insist in serving them, and he did that throughout his life. Thirdly, he eschewed all doubtful matters, preferring a very austere and simple life. In terms of his life in Damascus, for example, he lived in a school where there was boarding, there was room and board, and there were free meals. And he was extremely cautious about eating from the fruits of Damascus. And he indicated a number of times that he was uncertain because many of these orchards in Damascus were endowments that were owned for the benefit of orphans. And he was in doubt about the organization and the transparency of the organization of those endowments, and therefore preferred not to eat from them. It was related also that he would fast perpetually, except the forbidden days during the year. So that would be the first theme, a heart connected to Allah subhanahu wa ta'ala, and that would reverberate in our scholarly legacy and be probably the most fundamental and the most central and the most essential element of our legacy and of our legacy of the middle way. And that is put first, as some of our ulama teach us, because the heart that is not connected to Allah Azza wa Jal will merely reflect the knowables as the heart is. And as one has a mirror, and if the mirror is convex or concave, then the knowables will be reflected not as they are, but the knowables will be reflected according to the idiosyncrasies and the tendencies and the caprice of the heart itself. And the ulama 12 subjects a day. And the depth and breadth of his subjects are really awe-inspiring in terms of what the ulama of our legacy studied. In addition to language, in addition to, for example, writing about biographies, in addition to writing about ethics and manners and metaphysics, he studied very intensively fiqh and hadith. But the study of fiqh and hadith was not merely the study of furu'at, was not merely the study of positive law. It was the study of law within the envelope of usul, of legal theory. It was law within the envelope of al-qawa'id al-fiqhiyya, legal maxims. It was law within the envelope of the maqasid, the higher objectives of the sharia. It was law in its most complete and pure form, integrally and organically linked to all of its ancillary sciences. Because were furu'at to be studied and sacralized in themselves, we would most certainly commit injustice. We would, for example, compromise that which is absolute, unchangeable, that which is constant and universal, for that which is contextual and particular. So he studied that. And it was at a time, as we mentioned briefly and earlier, that the madhab was in a state of development, that the views of the madhab in the two primary centers were compiled by Abu Ishaq al-Shirazi on one hand and Imam al-Ghazali on the other. But there was not any systematic study, critique and crystallization of the madhab in its most authentic and carried form. And Imam al-Nawawi would be the one to do that, writing as he did in a time where he had the corpus of law, he had the great skills of a muhaddith par excellence, and the skills of an usuli and a faqih par excellence as well. And he brought those skills to bear in refining and crystallizing the madhab. And for any of you, for any of us who are students of ilm, to look at the corpus of law from tahara all the way until the end, from A to Z, you can understand it's a daunting task to study it, least to say to evaluate it. least to say to evaluate it on the basis of the evidence. And Imam An-Nawawi was one of those great ulama within the Shafi'i madhab who possessed tremendous prowess in the field of fiqh al-dalil. And he would frequently go back to the original texts, the Quran and the Sunnah, and he would tie and locate the law to the primary texts. And he is an example of the embracing quality of the madhab, in that it embraces a fiqh of dalil. That is, Imam An-Nawawi was the consummate scholar as part of a tradition that connected to the prophets, alayhimus salam. Meaning what? He accepted, received opinion and received verdicts. At the same time, he interrogated them and tied them to their respective adillah. And that is also a very important and necessary, salient characteristic of our legacy and the best among our ulama. Thirdly, under this rubric, is that he possessed a very civil and courteous manner of discussion and scholarly debate. It's rare, as a matter of fact, I've never come across the instance when Imam